So we can see that capital punishment was rarely, if ever, imposed because Talmudic justice comprises stringent rules regarding the admissibility and sufficiency of evidence. Indeed, in the Talmud itself is a teaching that says that a court who convicts and executes someone once in 50 years will be known as a bloody court. And so it's very easy to see that with such strict requirements, rarely did capital cases meet the legal standard necessary. Now, although I believe in a very strict boundary between religion and the secular state, I would not argue, therefore, that we should change secular American law to be in line with halakha, with Jewish law. Nonetheless, it is valuable to compare this extreme caution that the Talmud, that Jewish law presents, that takes to what we have in the United States. We know from our own experience and from what we've already heard that oftentimes the conclusive evidence leading to a capital sentence here in the United States is either witness testimony that is suspect, such as a plea bargain or some other personal benefit and gain to those willing to testify, or it is based on material evidence alone. Under Jewish law, the witness cannot benefit from his testimony, and that invalidates him as a witness. If he has anything to gain from his testimony of any sort, his testimony is invalid, even if he meets all of this other criteria that I laid out earlier. But if someone were properly convicted and sentenced, then how should execution take place? And that brings us to the second major issue here, which is what happens today in the United States after conviction. What is our moral obligation, if any, towards those on death row? Well, in 1999, two lawyers who are father and daughter by the name of Nathan and Eliza Lewin wrote an America's brief, a friend of the court brief, in a Supreme Court case. And they used as the basis of their brief that the humanitarianism of Talmud law should serve as our example. The brief states that the Talmudic sages wanted the death penalty, 1, to be as quick as possible, 2, to be as painless as possible, 3, to cause as little disfigurement as possible, and 4, to preserve the dignity of the condemned. And we in the United States today, no matter how much of an advocacy for the death penalty we may maintain, is failing in all 4 of those areas. We note that Judaism punishes the murderer who is making a clear and coherent choice. The vast majority of cases in the United States today are not on that level. And that's where we ought to center our debate. For there are always extenuating examples. But to take just one theoretical, a drunk man who crazily kills for no reason is not a murderer in the first degree. He may be a sociopath. He may be a substance abuser. He may be a tortured individual whose punishment by society is just. But putting him to death is not justice. It requires a moral choice.